Good afternoon. As we reconvene, it is now 1:45, and we begin our panel on the regulation of digital markets. Now, if, as I know you have, been living in the EU or the US for the last few years, you know that there's been a great deal of activity in this area. Some might think it's insufficient. Others might think it's the fatal conceit at work. We'll explore those issues in this panel. Our panelists who are listed in your program are all well-credentialed. I'm not going to add anything more than their current positions that you see there. That would be carrying coals to Newcastle. We're going to proceed in the order in which the names appear in the program, and therefore we'll, without wasting any time, Eleanor, I ask you to get us started.
Thank you very much. Thank you very much for inviting me to the hosts of this actually wonderful gathering. Thank you. Okay, so I am going to say some words about regulating the big tech firms. I will be dealing mostly with competition law. And I just want to start out with a message sort of where I am going. I think it's appropriate and maybe an upbeat to think about some good messages that we might take away from thinking about commonalities rather than just divergences and differences. And that's where I'm going to end up thinking about, is there a path towards better regulation to the extent we do regulate big tech in antitrust? And I will talk about commonalities between freer trade and freer competition, as well as a kind of cosmopolitan quality of the antitrust community in thinking cross-border about solving the competition issues. So let me start with brief outline. A word about the huge challenges when we think about the digital economy and the questions they pose. I will go quickly into the abuses that are particularly in the antitrust field. I want to say something about what are those perceived abuses, and then how are they being controlled. US, EU, probably I'll get a little to UK, and then finally about whether there is a path towards harmony. There are about 7 companies that we talk about usually when we talk about very big tech. They are sometimes called GAFA, sometimes called GAFAM, also including NVIDIA and Netflix. They pose enormous challenges. This is the antitrust octopus, and it's not just antitrust, the abuses in controlling legislatures, possibly something controlling our minds, and something really controlling people in the world. There are challenges, big challenges that are not antitrust, and I'm just going over this very quickly to get to antitrust. The misinformation challenges, the control of fakes is very high on the agenda. The control of speech, the putting people off a platform because of the content of speech raise huge issues, sometimes encapsulated in the Section 230 issues. And they come up with some of the Supreme Court opinions that have been coming down in these last couple of days. I'm not talking about those, and I do want to say that the antitrust pieces are, you can call them a corner of the problem, but they are actually a big problem if we're talking about power and its misuses and how to control the misuses. So here I just want to say a few words about the kind of misuses that in Europe there are big efforts to control. In the US there are efforts to control. In much of the free world that is part of the antitrust family, there are efforts to control. And when we talk about the abuses, first of all, the enormous size of the big 7, 2 of whom are passing the $3 trillion market cap and bigger than most countries. There is no international antitrust. They are regulated or controlled to the extent they are by all of the national or for EU jurisdictional regional authorities. So you have the big tech that, given the fact this is about digital economies and they don't see borders, they easily pass over borders, they are global. To the extent they do abuses, it is global economy, it's not national, trying to be controlled in the powers that they wield by, let's say, little agencies on the ground. And there is a question as to how well the abuses can be controlled. For abuses, let me put them into two categories. One category fits perfectly with freer markets. And that is the category, incidentally, that the US antitrust cases are getting at. They are trying to facilitate the competition among platforms. They are trying to prevent each of the companies' blockages of interoperability and portability of our data between and among platforms so that there is more openness and more competition among the platforms. And all of the cases that have been brought in the US, and there are many of cases by federal government, either FTC or the Department of Justice, joined by most of the states of the United States. All of them relate in very substantial, if not 100%, to this competition among platforms and charging the big tech companies with preventing the interoperability among them. Then I said there's a second part. The second part you see featured in all of the EU cases. The EU will feature both, and that is competition on the platform. And the EU is very well known in pioneering the concept of the biggest big tech, what they call gatekeepers, are predating on their own platforms against rivals that they are hosting on their platforms, demoting them, for example, if they're providing search services or comparative shopping services, putting the alleged allegation is putting their own up first and suppressing the competitors, and doing so, especially when they get too good. These are the charges, and in EU, those cases are winning. So in US, we don't have very much of this argument of self-preferencing because our law in the US is pretty limited. It's our law of monopolization, the Single Firm Act. Single firms have no duty to deal with their competitors, and generally no duty to deal fairly, unless they are doing acts that is likely to increase their market power and usually limit output and raise price. So that's why US, because of our law of the Supreme Court, is narrowing the purviews of the cases. And EU, which many have talked before about the EU system, the EU system is, because of the market integration motivation, it preferences access. Access to a platform, for example. It is not shy to call a facility such as these big platforms akin to an essential facility to which firms should have fair access. So EU puts in this concept of fairness and contestability. I have this one slide here, just really, I'll go over it quickly, but just about power of big tech, where Justice Clarence Thomas, in a case that's not antitrust but free speech, is talking about the problem is private concentrated power over online content, and saying the power has to be controlled. It is very serious. There are no comparable alternatives. So I mentioned the US cases against the GAFAM, Google, Apple, Facebook, Amazon, and Microsoft, plus one or two. There are also private cases I didn't mention. They are mostly pending right now. We're waiting for a couple of decisions, like one against Google momentarily. the cases are hard in the US because the law makes it very hard for the plaintiffs to win the cases. In EU, the cases are being pretty successful, and as well, the EU has determined, as I'm sure most of you know, the case-by-case law is just too slow. It takes years to process one of these cases through the court. And they thought that the cases also under competition law have some paradigms that are too narrow. For example, what is sufficient market power? And according to the EU, because I'm going up to the fact that they adopted legislation, they are saying these companies that are the gatekeepers have substantial market power. They shouldn't be able to litigate at every single case like Google says, I don't have market power, the competition is a click away. So they adopted this regulation to bypass the limits of the case-by-case law and the limits of its substance. They adopted the Digital Markets Act. It's in very early stages now. They identified about 18 do's and don'ts, thinking that maybe some simpler rules will keep the companies in line. But they adopted a huge regulatory system to go with it, and we'll have to see how it works out. So we're coming to the end of my time, and I won't do more on that subject, but here is my last slide, which is how is the world doing in controlling antitrust abusive behavior of the digital firms? And my first line is, it can depend on your point of view. And of course there is a point of view. Leave these big firms alone. They're successful. They're giving people a lot. They're giving people a lot that looks free, although they're getting our data, but they're still giving us a lot that we never had before. And they need the freedom in order to do the invention. And then the other point of view, which is very mainstream in Europe and a lot of the world, and now, given the, let's call it the neo-Brandeis revolution or rhetoric, whichever you like, the view that these firms and that firms in general have, at least a lot of them have, huge power that must be controlled, many abuses. We must be much more alert to controlling the power, and that there's a fairness concept akin to the anti-competitive concept that has to be taken account of in order to prevent the abuses. So finally, if I can get, because my time's up, just one word about, I promised you a word that would be somewhat optimistic. I think that there is room for converging norms. The antitrust community, heads of competition, are trying to do this. They meet with one another. One forum is called International Competition Network, sorting out the commonalities. I think that there is a way to look at the problems, a set of practices, which I would say very compatible with the decision in which Judge Ginsburg was prominently involved, the United States against Microsoft case. If you simply derive from that case what big firms that have monopoly power should not do, you probably would get a set of principles which there could be convergence in the world, notionally, norm-like, but at least working towards the commonalities and not the divisiveness. Thanks.
Thank you, Eleanor. Aurélien?
All right. Well, thank you very much, Judge Ginsburg, for having me in this panel, and thank you for the organizers of the Transatlantic Law Forum. It's great to be here, and of course, George Mason's Law and Economics Center. Thank you very much. So my point today is to talk about regulation of the digital sector and, of course, AI from a comparative and from a transatlantic perspective. My message is very simple. I'm going to try to demonstrate that it's very difficult to regulate those sectors. And of course, it's very difficult to converge from both the US and Europe perspective, and Eleanor has already pointed that quickly. So First, on AI and the Digital Market Act. Eleanor mentioned the Digital Market Act, but I just want to step back for a moment. The DMA is a very controversial regulations and can be said to be over-inclusive in many ways because the companies cannot justify or they don't have an efficiency defense or they don't have proportionality defense into the alleged anti-competitive conduct. They just cannot. So it's like almost like a deontological prohibitions and where you just have to apply it, even if it sometimes can be pro-competitive or there might be some efficiency defense. But at the same time, I'm going to argue that the DMA is also under-inclusive. It's a piece of legislation that was proposed in December 2020, and it really get into effect, in force, just March 2024. It's already under-inclusive because, well, since then we have this kind of like ChatGPT AI revolution. I mean, even though AI is very old, it's from the 60s, but at least the ChatGPT and availability to the public has really shaken the regulators. And when it comes to that, well, surprisingly, the Digital Market Act is under-inclusive. Absolutely no word about AI, no word about artificial intelligence, and I think it's embedded into the digital sector. So there's under-inclusiveness to three aspects. First, the designation of core platform services, which is basically the services, or what you say in the US, the lines of commerce in the digital sector that are the targets of the DMA. Second is the gatekeepers, which companies are within the scope of the DMA. And finally, it's about mergers, and it's particularly important when it comes to AI. So first, the designation of core platform services. What are we talking about when it comes to Digital Markets Act? Just very quickly, Digital Markets Act, it's not about markets. It's not about digital markets, because nowhere we define markets, and the point of the Digital Market Act is to move away from market definition and market shares. So it's not about digital markets. It's a Digital Markets Act that tries to move away from digital markets in order to impose this notion of core platform services. So forget about markets, it's about core platform services. So these are the list of the core platform services that the Digital Markets Act regulates: the online intermediary service, the search engine, the social network, video sharing, I mean, a number of independent services. This is like iMessage and WhatsApp. Operating system, web browsers, virtual assistant, kind of like Alexa, cloud computing, and finally advertising services. That's great. So you end up having this, on the right-hand side, this kind of core platform services of those companies to be falling within the scope of the DMA. As you can see from this list, there's no mention of artificial intelligence, which is like core when it comes to data scraping, data collections, and using artificial intelligence into the digital services. So we can say that basically the Digital Markets Act, which is a very recent piece of legislation, is definitely obsolete already. And I hold that from European regulators saying that, oh, we should update the DMA that just got into force in March 2024. It's already obsolete. So that's the difficulty of regulating. What are we talking about technologically? How can you regulate the technology when we have no idea how AI is going to be in a few years, or the blockchain, or the quantum computing, which again, are not in the DMA. So that's the difficulty, the topic we're talking about. But then also the subject, the designation of gatekeepers. Like, okay, as Eleanor mentioned, okay, we're going to target the biggest companies. Well, the thing is, those biggest companies have changed. And what we see over the last 2 or 3 years is just a massive increase in the valuation and the power of one company, which is NVIDIA. So the market cap threshold for the DMA is 75 billion euros. When you make 75 billion euros, you're very likely to fall within the scope of the DMA. Great. So NVIDIA is $3 trillion and doesn't fall within the DMA. second aspect for the threshold for triggering the DMA applicability is the end users threshold. 45 million end users. I'm not talking about business users. But let's take this idea of 45. Okay, 45 million. OpenAI is 180 million. 180 million monthly end users is growing, and it doesn't fall within the DMA. So that's the difficulty of designating the company. I'm going to try to move quickly. The final aspect where the DMA is already obsolete is the review of mergers. When you talk about DMA, it's like the Article 14 of the DMA says that you have an obligation to notify all the mergers. What is it talking about? It's talking about all the digital mergers on the digital sector. So first, we don't know what the digital sector is because nowhere in the DMA is defined. Suddenly, we had the core platform services, and suddenly it's digital sector. Not even digital markets, but digital sector. So the scope is poorly defined. But most importantly, when it comes to AI, what we've seen over the last few months is not acquisitions, it's not mergers, it's minority interest, like Microsoft having a minority interest in OpenAI, Amazon having a minority interest in Anthropic, and so on and so on. So it's not an acquisition. It doesn't fall really within the DMA. That's what we call the quasi-mergers. Completely outside the scope of the DMA. So the takeaway is that it's very difficult to dynamically regulate dynamic markets. It was urgent for the US to wait in kind of transplanting the DMA. That's why most antitrust bills have failed. And there was one bill that passed in terms of merger fields. And the DMA's failure also fundamentally about the regulatory dialogue. I was discussing this with Olivier Garçon, who is the leading of the DG Comp, which is in charge of the antitrust. The DMA is based on regulatory dialogue. This dialogue is already failing because we issued non-compliance decisions, which breaks the dialogue. We, a couple of days ago, heard about the alleged violations of the DMA by Apple when it comes to anti-steering rules. And we also hear some parallel investigations where the EU is unpleased with the bundling of Microsoft Teams within Microsoft Office. So Microsoft is already a designated gatekeepers, and we're talking about the fact that software such as Microsoft Office are not designated in the DMA. That's also a failure. But irrespectively of the pitfalls of the DMA, the Brussels effect's gonna take place broadly, like in terms of regulatory transplant, but most importantly in terms of technological one-size-fits-all, where the company can say, well, we apply technologically one solution of the DMA globally to our globals. What about the regulation of AI? I'm just going to go very quickly. There's the EU AI Act, and we have the US kind of AI Bill of Rights. Very quickly, I just want to say that the EU AI Act is about effectiveness. It's legally binding, where the Bill of Rights is not legally binding. What about the extraterritorial effect into the EU's AI Act? It's core to the EU AI Act. It wants to have extraterritorial effect. The point is to, like, now it's like, irrespective of the users or where the company is located, it will apply, and that will have a de facto kind of Brussels effect. Whereas the US Bill of Rights, it's meant not to have extraterritorial effect. So just very quickly, I want to move on and say that this Brussels effect is by default, like the EU is in a train regulating quickly with legally binding regulations, where the US, because of congressional blockage and because of perhaps White House willingness to put some non-legally binding rules, is in totally different path. But yet, you have this rhetoric of convergence. Well, DMA prove that there's a divergence. Also, you have the USTR withdrawal when it comes to cross-border data flows, which is breaking the US historical stance on free trade of on trade and digital trade specifically, and that's surprised the Europeans. So the Americans are surprised by the DMA, the Europeans are surprised by this break of the historical perspective from the US. So there is some kind of divergence. Yet, we talk about regulatory dialogue. So you have the EU-US Trade and Technology Councils, which have been created 2 years ago. I don't know what comes out of it. It's very unclear. It's kind of opaque, like it's not transparent meetings. We don't have, so there's nothing coming out of it. We have AI Public for Goods, that's only a scientific corporation. And we just had a panel talking about China and the fact that the Europeans and Americans are unfortunately divided when it comes to China. And that's like what we see. It's the difficulty of converging, especially in a time where China's leadership technologically and China's undemocratic values are also having their global effect when you think of also the global south, Latin America, Africa, and other aspects of countries of the world. So that's my conclusion. The difficulty of regulating when it comes to DMA, which is already obsolete and is a few months old when it comes to compliance, and the difficulty of converging because beyond the rhetoric, we're not doing anything substantial. Thank you. Oh, sorry. That's
okay. Great. So I'm presenting, this is based on a recent book that I wrote together with Henry Farrell. And I really want to do three things. I want to first say that we have an outdated kind of caricature of how digital networks and globalization work together in terms of politics and law. I want to give a different caricature. It's a simple story, which I think helps us understand a lot of the confusion that exists in the U.S.-EU relations. And then I want to kind of apply it to that. Say, when are we getting convergence, divergence in this relationship? And I worry that we're in kind of a self-reinforcing negative spiral that will lead to poorer and poorer relations across the transatlantic. And maybe we need to address that, I would say, sooner rather than later. So the first is that it is remarkable how recent these digital technologies are, yet how consequential they have been for global politics and global interaction. So if you think about Google as a company, it's a very recent company. If you think about the financial transactions that are made possible through these networks, the production systems that are made possible through these are all really new, and we don't really understand how they create a new form of politics. And there's a simple story, that's the first caricature, and it's somewhere in your head, I know it is. Thomas Friedman wrote it. You might have read different iterations of it. The most common is the world is flat, but the one that's more about technology was this piece he had in 1999, where he said, we're no longer in a world of the wall, but we're in the world of the web. And he was saying, it's the end of the Cold War, the Berlin Wall. We're not going to have great power conflict anymore. We're in this new world, the World Wide Web, because that was really, technologically very sophisticated at the time. But that technologically sophisticated World Wide Web was going to mean that firms were going to be in the lead, that states were going to be sidelined, that we were going to have decentering of power, and that going forward, great powers weren't going to be involved in these types of disputes. And of course, if you've been alive for the last 5 years, you know that this isn't true. Everything from the SWIFT system, which is critical, it's basically a digital communications system for banks, 5G networks, the ASML, there's a company that makes lithography for semiconductors. It's stuck between the US and China. The technological landscape is in the middle of a great power war, and it's, of course, US tensions with China, but it's also Europe completely frustrated with US firms and their control over these markets. So how do we make sense of this? The current, that myth that it's not just Thomas Friedman's myth, it's the myth that underpins the European Union's effort, the four freedoms. It's all about openness. It's the idea that rules-based systems will solve our problems. It was also the myth that we had vis-a-vis China. It was constructive engagement, that was the name we put it. But this is not just like a one-book wonder, but it is somewhere in your head. It is still how we make sense of the world, and that's why we think all of these conflicts between the US and Europe are so surprising. And I'm going to give you this other perspective, which I hope makes sense of why it's not that surprising, and we need to really focus on it. So this move that Henry and I do, it has 2 points. The first is if you've ever flown Delta or Air France, if you're coming from Europe, you landed in Atlanta. Now, this is a very physical description of what I want you to understand, but it is the reality that companies don't decentralize. their networks. They actually centralize their networks. This is the hub and spoke model. It's a very, anodyne example. It does mean that you're probably going to get stuck drinking many flavors of Coca-Cola if you ever take Delta in Atlanta. But if you're trying to get from Caracas to Cancun, you're stuck there in Atlanta. So this is not just about airlines. If you think about this product, which if we leave it in another room for too long, we start twitching, right? This product is run by one of two operating systems, Apple or Google. It is by a chip that's made by one or two companies, TSMC or Samsung. And if you make a financial transaction, it goes through one about 10 banks globally. That is a very different world than what Thomas Friedman or the Four Freedoms or it's a world of centralization. And that is just the first move. The second move, at least for Europe, is that they have basically failed to be a competitor in these core industries. This is just one example of ICT. I could do platform firms, I could do infrastructure products, but either the US or China or Korea Europe is almost solely reliant on these companies. So that centralization has left Europe in many places on the sideline. Well, the third move is that webs, what do? They do not centralize power or decentralize power. They centralize power for an actor, for the predator who sits at the center of the web. They bring resources to that actor. And in my story, it's the state. It's either the United States, China, the European Union. These are the people who use law over these economic actors in order to influence policy. And they do that through a number of ways. They use it to surveil their adversaries. So if you think about the Snowden revelations, we used our infrastructure in order to do that. If you think about the export controls that we're doing vis-a-vis China, it's the same thing. We're using economic networks to cut people or choke people out of these systems. And so what the transatlantic relationship is being reformed because the bargain isn't the old bargain. It is now a bargain either of asymmetric interdependence and with national security elements. And so that was kind of my alternative story of where globalization is going. And now I just want to quickly think about, well, how does that impact US-European either divergence or convergence? And I'm a simple caveman international relations scholar. And a simple caveman international relations scholar has to use a 2x2. That's kind of why, I don't know why economists have trilemmas. We have these boxes. We think they're special. But what I want you to see is that, we had a period for a long time where there was no rivalry in the international system, the heyday of globalization, the 1990s period. And we also had a period where there was symmetric economic exchange between the US and Europe. So in 2000, the year 2000, Google was barely a company. Meta, Facebook had just been founded. Europe thought it could play in these markets. It thought Deutsche Telekom was going to rule the economic e-commerce world. Okay? There were a whole state of these legacy European providers that thought that they would have a major stake in the global e-commerce world. And so the negotiations between the US and Europe were very different because we were in a world of no security concerns and economic symmetry. But we have increasingly moved into a very different box. It's a box where there is that asymmetry. Remember that chart where Europe is not on the list? And we have rivalry because China and the United States see themselves as competitors. So when the US and the EU negotiate over data privacy, over antitrust, over any of these issues, the fundamental structural conditions have changed. We are no longer in a world of simply thinking, how do we get more or less of the pie? How do we distribute it? It's about control over these infrastructures that have not just economic consequences, but also geopolitical consequences. I'm just going to quickly make a final kind of point about how this affects our relationship, because these interactions shape our preferences in our countries, in Europe. What does Europe want in terms of regulating the digital economy? It is shaped in part by what the US is doing, and vice versa. And so on the top, you see Edward Snowden. The release of this information that Edward Snowden made is often kind of, oh, well, it had no consequence. Oh, he did this thing, but we are still feeling the consequence of those revelations, because in one work that I've done, I show that really affected how GDPR, European privacy rules, were negotiated. That release demonstrated to Europe the security rivalry, that this was not just an economic domain. This was a domain that was also marked by a national security concern, and that they had to worry not just about would companies grow, but also would their data be used for other purposes than they wanted. And when Amazon and different companies tried to lobby, they were increasingly hit with, well, you're just an arm of the US state. Now, so that's a kind of example of where these structural dynamics are causing divergence, a strengthening of Europeans' emphasis on privacy issues. But most recently, you see in the Ukraine conflict has actually spurred cooperation. The US and Europe had been negotiating a new version of these privacy accords, and it had stalled until the Ukraine conflict happened. And it became clear that Europe needed to give the US something, because it needed the US to help it succeed in the Ukraine war. And so what I want you to see is not that the security and asymmetry change leads just to divergence or just to convergence, but that it changes the nature of these interactions. And I think a lot of people are not paying attention to that. So the final point is just to say these global digital networks, they are not just market interaction, they're also about power, often about coercion, that policymakers are often using them in a very, I would say, there's not a grand strategy of how they're being used, but it's to deal with wicked problems that they're facing in a day-to-day context, but that can have self-undermining effects for the transatlantic relationship. And so we need kind of a new vision of what is economic security, how do these networks interact, in order to kind of save the best parts of globalization. Because my concern is that if we don't think about a new language, new sets of institutions, that we are likely to, everything is going to be a security threat, all these companies are dangerous, and that we won't be able to have the vibrant global economy that we've enjoyed for the last 2 decades.
All right, Mike, thanks for hosting us, and Judge, thanks for being our moderator today. So I'm the square peg on this panel. This is the Transatlantic Law Forum brought to you by the Law and Economics Center. I'm not really a lawyer anymore. I've never been an economist, and instead of talking about transatlanticism, I'm going to spend most of my time talking about the Chinese Communist Party. So let me set the stage for what I'm about to say with a roadmap. I'm going to talk about the background, the sort of strategic context in which this conversation is happening, that context being great power competition between Washington and Beijing, particularly when it comes to the quest for technological supremacy. Then I'll discuss some of the American advantages in that contest for technological supremacy. So big picture, what does the Chinese Communist Party want? Well, Xi Jinping has been very clear. What he seeks is the great rejuvenation of the Chinese nation. By that, he means that the past 200 years of Western global domination is an aberration over the 2,500 years of continuous Chinese civilization. So for Xi Jinping, he wants to restore China to its rightful place as the center of the world, the Middle Kingdom, or Zhuangguo, to use the Mandarin term. Now, if China is the center of the world, it follows from that it has the right to rule other states as tributaries. The Chinese word for that is Tianjia, which means all under heaven. So ultimately, what the strategic objective for Beijing is to displace the United States as the world's leading power and to remake the international system in China's image. This is, you might put it, an existential challenge that the United States faces and that our partners and allies face as well. We've never faced a rival that is capable of challenging U.S. power on all these different axes, militarily, culturally, technologically, economically, and so on. So what are our comparative advantages then in the effort to achieve or maintain technological dominance? Our alliance system, our values, and our private sector. And before I get into the details of each of those, let me just say it's important for the United States and for the West, broadly understood, to play the game on terms that are favorable to us rather than trying to play China's version of the game. We didn't win the Cold War because we had a better 5-year plan than the Soviets. We won the Cold War because we had a better system than the Soviets. And the lesson we need to draw from that is we need to play our version of the game. We can't outcompete China by doing industrial policy better than the Chinese communists or by doing civil military fusion better than the communists. We can outcompete China by relying on our comparative strengths. One of which is the alliance system. The United States is really, really good at building durable, cohesive alliances of like-minded countries based on shared interests, based on shared values. Alliances are force multipliers. They allow the United States to get more bang for its buck by outsourcing certain responsibilities to treaty partners and so on. NATO is a good example of this, although maybe you might say Europe has been outsourcing some of its obligations onto the United States with some justice. The Five Eyes Partnership, the Quad, which has been growing in importance in recent years, and AUKUS, announced by the Biden administration in the early years of the current presidency. China has alliances too, but those alliances are much more ad hoc and situational. Their partnerships, such as they are with Iran, with Russia, with North Korea, don't have the same cohesion as American-led alliances. American-led alliances are more cohesive because, as I said before, they're based typically on shared values and shared interests. China's alliances, such as they are very different. China doesn't really want peers in the way that the United States looks across the Atlantic and sees London as a peer nation, or across the Pacific and sees Japan as a peer. What China wants is clients. China wants satrapies. These are alliances of convenience rather than alliances of conviction. And we know that because China's so-called allies are always looking over their shoulders. For example, ongoing territorial disputes between Moscow and Beijing. What's missing? Trust. Trust is what's missing in Chinese-led partnerships and alliances. And again, I hesitate even to use the A word in this context. Let me give you an example. When I was in office, I was in Africa. I was meeting with a cabinet minister, and this person refused to meet in their ministry building and instead insisted on meeting at a private hotel. Why? Because a Chinese state-owned enterprise had built the ministry building. And the minister was confident that this was not going to be a quiet, confidential conversation. They didn't trust their economic partner. That is an enormous advantage for the United States and our European and other Western partners. Also, American-led alliances are much more powerful. You can measure that principally in military terms, but also in economic terms. The US accounts for about 25% of the world's nominal GDP. China's about 18%, so rough parity there. Now let's add our allies in. If you add the G7, the rest of the EU, South Korea, and India, the US-led bloc is over 60%, well over 60% of global GDP. Let's let China add Russia to its side of the ledger. It can add Iran to and North Korea, but those are rounding errors. China gets to a little over 20%. 60 plus versus 20%, the Western alliance has enormous economic clout. I like our odds. Our second comparative advantage is our values. Nobody in the global south, nobody in the world's contested spaces is saying, when I grow up, I want to live in a communist dictatorship. They want what we want: prosperity, freedom, and accountable government. For the Chinese Communist Party, technology is an instrument for maintaining and expanding the control of the party's state. Surveillance programs, communications programs, medical, AI, it's all about improving the state's ability to maintain social control. We see things differently in the West. Technology should promote human flourishing. Technology should promote human freedom. And those values shape what we do with technology and, crucially, how we invest in technological innovation, which brings me to my third comparative advantage, which is the private sector. In the West, and particularly in the United States, private companies are a critical source of investment in cutting-edge technologies such as quantum computing, such as artificial intelligence. Meta, Alphabet, Amazon, even Apple, which has been late to the game, represent an enormous share of total U.S. investment in artificial intelligence in particular. In 2022, our country invested a total of about $43 billion into AI-related research. Of that, only about $4.5 billion was invested by the U.S. government, primarily the Department of Defense. So you're looking at a 9-to-1 ratio, more or less. The policy goal here should not be to encourage the federal government to spend more. The policy goal here should be for the federal government to create the conditions in the marketplace that are conducive to continued private investment. That's how we're going to outcompete the Chinese Communist Party, not by trying to do civil-military fusion better than Beijing does. Now, that policy goal is one that is not often honored, and as we've heard in this panel, there's an increasing amount of regulatory divergence, I'd go further, regulatory tension, diplomatic tension between Washington and Brussels and other European capitals. The only thing I'll say about the Digital Markets Act, which we've covered pretty thoroughly already, it's not just about antitrust. It is. It's not just about privacy, although it is. There's more than a whiff of protectionism going on here, too. Of the 6 companies that are regulated under the DMA, 5 of them are American companies. 1 is a Chinese company, 0 Europeans. Why are no European companies in scope? Because Europe has not innovated. We're now starting to see a familiar pattern play out where the United States is the engine of technological innovation and Europe is the engine of global regulation. That's actually by design. Some in Europe describe the EU as a regulatory superpower, by which they apparently mean to bestow a compliment on the EU rather than an insult. This trend has much broader implications than we can get into today for economic dynamism and economic growth. The point I want to make here is much more narrow and focused. This transatlantic dispute and these transatlantic tensions threaten to undermine 2 of our main advantages in our competition for technological supremacy with China. First of all, the alliance system. If the West is a circular firing squad, we are not aiming at Beijing. We are allowing ourselves to be distracted from the great strategic challenge of our era by focusing on transatlantic disputes. The only people who benefit from that, besides a couple of regulators, are Chinese Communist Party apparatchiks. The second advantage that is harmed by these transatlantic disputes is private sector innovation. The greater the regulatory burden that is placed on tech companies, on American tech companies, that's going to threaten to slow the pace of innovation and create opportunities for Chinese state-owned enterprises to leapfrog us, and we're not going to like it. What that world looks like. Last thing I'll say, I don't want to be seen as a shill for Silicon Valley. Very far from being a shill for Silicon Valley. But I would like to say that it's very important for the American private sector to take a look in the mirror and consider its own obligations in this space, not just to shareholders, but in order for them to enjoy the political space they need, the legal and regulatory space they need to innovate, they have to be seen as not taking sides in contested political, economic, and social disputes. I'm out of time, so I'll just close by re-emphasizing the need for technological neutrality. If American citizens look at Google and they see the disastrous rollout of Google Gemini with its woke artificial intelligence returns to basic queries, that is not going to provide the industry with a solid foundation of political support that makes its role as a key innovator, that protects its role as a key innovator in the high-tech space. I'll end there. Thanks.
I think I should start with Eleanor if you have some follow-up.
Okay, thank you. All right, a couple of comments. Since we were talking about UK regulation and the Digital Markets Act, is it already obsolete and irrelevant, and does AI make it irrelevant? I believe not. I believe that the abuses that are foreseen are actually exasperated by AI because of the data component and the AI requiring and needing more and more data for the functions it does, and tipping the scale so that the big gatekeepers are more and more entrenched. Is it a problem that Digital Markets Act doesn't mention markets? No, the whole idea of Digital Markets Act is if the EU can be wise about designating who are the gatekeepers, and there aren't that many, it eliminates the need to prove certain things, like to prove a market, and it eliminates the need to prove that tinkering around with your interoperability to make a bigger moat to keep others out is wrong. So I think that there are, and I think this is a contribution to the world because it has centered conversation in the world around companies with substantial market power, with platforms, and certain practices that are the worst for entrenching the dominant firms and helping them to suppress the innovation of the others. Here's where the innovation argument comes in, because the dominant gatekeepers have been, and this has been well documented in the EU cases, they've been suppressing the innovation of the smaller firms that otherwise could be very successful. One other point I want to make, which hasn't been said here today yet, but it's relevant to this conversation as well as to almost all the others. Do not underestimate the backbone of free trade and competition that underlies the European treaties. Even though Europe has undoubtedly become over-regulatory, it also has a backbone, maybe you'll say this is more on paper, but it's very substantive, that tears down undue parochial barriers of the member states and facilitates the free movement. And it's actually so obvious, but we know it so well that we don't say it. If it can be put on a higher platform, I think it helps us recognize the really great contribution that the Treaty of Rome has made. Thanks.
Yeah, so I agree 100% with what Nathan has said. Just perhaps one addition. When it comes to the Digital Markets Act, it's true that it was 5 American companies, 1 Chinese company, ByteDance for TikTok, and the Europeans have just added Booking.com, which is a European Dutch company, Booking.com. And I think it's totally right that we cannot ignore the fact that there was some threat or some claims or of protectionism before the WTO, and I think this is, beyond Booking.com's practices, which is mainly some anti-steering practices, but which have been solved in some German courts and Dutch courts. So it's interesting that Brussels bring it still at the European level, but I think it's also a strategic move in order, before the WTO say, well, it cannot be a protectionist tool because we have one European company that is designated. So it's an interesting change. When it comes to...
Well, yeah, just one second. I want to just say something about the Booking listing. So Booking.com runs more than one platform used for hotel bookings in particular. And the reason that they are in the crosshairs is their policy of saying that if you want to be listed here, let's say you're a hotel, you may not list lower prices on your own website. We must always have the lowest price. It's exactly the policy of Amazon as well.
The price parity
which
clauses.
has also drawn fire as on the ground that it prevents actual price competition. But of course, if that were enforced, it's so completely inconsistent with the business model, saying you can always get the lowest price here, that the head of the company of bookings has said, we will consider leaving the EU.
Yeah.
Now, since the jurisdiction will apply to any activities of the EU, to be taken seriously, that would mean we would consider no longer handling hotels and bookings in the EU.
For European
or
company.
dividing up the company and spinning off the EU to be regulated and the rest of the world on its own terms.
Yeah, for a European company not to operate in the EU, that would be quite a shock and quite a...
Yes, but what's already happened is that among the other companies, the U.S. companies listed, 2 or perhaps 3 have already said that there are services in the U.S. that they cannot offer in Europe under the DMA or that they, in the case of Apple's AI, that they will have to postpone to figure out how they can, whether they can offer it in Europe.
Yeah,
so there is going to be the regulatory blowback in terms of, not that it's just purely rational decision making, that the market is too hostile for some of the services that are being offered.
Yeah, correct. I think that's one thing, the effect of the DMA. But when it comes to enforcement of antitrust, competition law, to digital companies, it's obvious that there are some anti-competitive practices, but it doesn't mean that by regulation, the only solution is regulations. It's just enforcement of current laws. And we all know that antitrust laws are so vague that it gives a lot of flexibility for enforcement. And as we talk about here in the Transatlantic Law Forum, it's good to just remember the differences between the US and the European system when it comes to antitrust enforcement. The US remains led by private enforcement, whereas the EU remains mostly dominated by public enforcement, so it's natural. We have a judiciary-led system in the US. We have an administrative-led system of antitrust enforcement in Europe. When it comes to antitrust, we talk about antitrust injury in the US, almost like a tort. It is a tort, and sometimes it's a criminal injury, criminal liability. This is not the rhetoric we have in Europe. Most of the time we talk about competition as a public order, as organizing the market, as an order, like ordering the market, and it also comes from this order liberalism that has so much influenced European competition policy. So when we talk about convergence in terms of regulations, we have to understand that there's also a divergence in the culture, in the legal culture, not only because the US still common law and Europe still kind of dominated by civil law, but beyond that, when it comes to antitrust and competition or rivalry, the way there's discussion about technological company and how to regulate them, there's a fundamental difference in the legal culture and the due process, the showing some evidence in court is extremely lengthy, extremely difficult in the US, whereas some have criticized the lack of due process in Europe, but that's the timely, efficiency, very quick interventions where you have sometimes the European Commission that is judge, executor, and arbiter. And the only way to challenge those decisions is to go before the European Court. But you already have the decisions and the fines by the European Commissions, which you don't have in the US. You have to sue before the court. So I just want to, there might be some regulatory divergence, but the greatest divergence to me remains the legal culture and the lack of convergence in the legal culture. The answer would be perhaps to emphasize or encourage private enforcement of antitrust in the EU. We don't have some sort of thing like class actions or private enforcement. This is just very, very, very embryonic in Europe. And perhaps reverse-wise, in the US, there might be some rooms for public enforcement in those antitrust bills that failed to pass in Congress. Most of them, when it was proposed by democratic representatives, they were focusing on public enforcement. So perhaps there's a midway here where we can encourage public enforcement and encourage private enforcement in Europe and in US, where there will be some regulatory convergence by legal culture coming closer together.
Abe, want to say something about what you heard?
Sure. I want to underscore what Nathan said about, that we could shoot ourselves in the foot. We have these advantages, I think, in the international system, our alliance network, the kind of economic relationship that we have with the transatlantic community. And I am very concerned that the inward-turning nature of U.S. politics is then going to undermine those things that create our innovation ecosystem, the things that drive our economy forward. During the Cold War, it was not just about separation between the US and the Soviet Union, but it was also a politics of openness within the West, which included a wide range of things, whether it was about innovation across markets, about trade agreements, about immigration, about a belief in democracy. These are all things that then led to our advantage. And my concern is that we are self-eroding our advantages. So we tend to focus on what can we do to stick it to China, which we can have that conversation. But if we're going to stay ahead in the global competition, we have to innovate. And that relies on stable property rights, which relies on democracy and democratic institutions that we will follow. And it also requires that we have openness in terms of how we build our markets. And I'm worried that there's no consensus about the trade regime anymore in the transatlantic community. There's also a failing consensus around migration. There's a diminishing consensus around universities and innovation systems that derive from universities. All of these things we will lose this battle because we shoot ourselves in the foot.
Nathan, if you want to add something, I have a question.
Let's get to questions. Yeah.
My question for you is this. Is the presentation that you made, are you implicitly accepting as a premise Abe's description of centralization as a core to these technology firms?
I don't have a good answer to that. And this sort of goes back to, I think, Eleanor's question. What is your explanation for why we have seen concentration in the industry? Is it because these firms have provided a service that is valuable and therefore they have naturally expanded their market share by fair play, or is it because they have expanded their market share artificially by unfair play? I don't have a great answer to that question as applied to the United States. I do have an answer to that question as it applies to Chinese companies. And the answer is state-owned enterprises are heavily subsidized by the Chinese Communist Party. The reason why, and it's not just in the tech field, it's in the energy transition field, it's in electric vehicles and the batteries for electric vehicles, and it actually goes to trade. I think part of the reason why the mid-1990s, early 2000s consensus in favor of global trade has eroded is in part because of how unfairly China has competed in a number of key strategic industries. The pattern has played out so many times that it's become predictable. Western company invests in China. As a condition of market access, you must sign some kind of joint venture with a Chinese company that provides for the sharing of intellectual property. The company, subsequent to receiving the infusion of Western technological know-how, then receives enormous backing from the Chinese Communist Party. The products are then dumped onto the international market at sub-market prices, driving out Western competitors. So batteries, electric vehicles, solar panels, the list goes on. So that's a non-answer to your question. I don't know about the answer as applied to the US and other Western firms. I'm worried about what competition looks like and bad behavior producing those outcomes in the Chinese market.
I think you can soon add civil aircraft to the list.
And Boeing has a major manufacturing facility in China.
Although I'm not sure that's going to help them anymore. Let's take some questions. Yes, sir.
Thank you very much for your statements. I would like to raise one issue regarding private enforcement of competition law in Europe. You probably know that we tried, since Courage, we tried to encourage private enforcement. And it has actually seen some difficulties simply because the substantive private law questions regarding damages, for example, we don't have treble damages. And the procedural questions associated with that are or would basically demand answers in our procedural and legal systems that would, just for the sake of competition law, have a huge impact on other areas of private and procedural law. And probably the common sense is we think it's just not worth it, because our system has grown since Roman times. and has grown over those centuries. And we think just for competition, it doesn't make sense to introduce, for example, disclosure rules in procedural law that we don't have in continental Europe. So that's just one brief intervention. The other point is, and that's a question for Professor Fox, on your last slide, you contrasted the two different approaches to regulating or assessing the competitive position of big technological companies. And according to your huge experience, how much of the choice between those two approaches, or to what level is that choice colored by the question whether the company is located on your own territorium and pays taxes there, or whether it's seen as some kind of covert trade law policy to treat the ones from, say, the United States from the European point of view a little bit worse than your own tech giants, if you have some? Thank you.
All right.
Wait a minute, was it Eleanor? Did he not mention you?
Shall I go first? Okay. Yes, thank you very much for the question, which is very relevant. It can be framed, are all of these actions in the EU courts and commission, are they really parochial? Are they trying to just get our firms because our firms are so good? This is a question that people disagree on, and I'll tell you my point of view on it. I do not think that they are parochial, but I also think that those people who are part of the commission, et cetera, who have parochial instincts are very happy about it because they're getting the US, they're trying to they're trying to at least put bigger obligations on US firms. I work with the European Commission. I know these people very well. I know who brings the cases. I know their thought processes as they bring the cases. The cases are very, very compatible with the core of EU law, basically on access. So I think that they are not discriminatory. Could I say a word on national industrial policy right here? Because I think that the current administration on competition in the EU is against parochial industrial policy. And the current head of competition, his name is Margrethe Vestager, but she's only in office for a couple of more months, has been very strong in saying competition law is about competition. You don't let growth of market power happen because of the claim that we need a national champion against China, which is a very particular example, the Alstom-Siemens merger, which was a merger between two firms that would be a merger to monopoly. And there were lots of people in the EU who said, let that merger go through because otherwise China's going to come over and take over everything. So she was firm, and the Commission was firm in saying this was a merger to monopoly, and basically underlying it. You don't just play the China card all the time. Just because there is possibly China coming in is not a good reason to let the merger go through. However, there's a lot of opposition to that point of view in Europe, in the European Commission, and we have to wait and see. With the new Commission coming on, it's not at all clear that the industrial policy China card will be kept out even of the antitrust merger review.
Let me go back to the first part of your response, and perhaps to the gentleman who asked the question. But it's my understanding that the Netherlands has become quite a friendly forum for class actions now. That some adaptations may have been necessary in the procedural rules. I'm not sure about that. But American law firms are flocking to the Netherlands in order to pursue this opportunity. Germany to a lesser extent. And of course, the UK has its own opt-in, opt-out system based on whether you're a UK resident or not. And that the CAT, the Competition Appeals Tribunal in the UK, has been paving the way and facilitating for class actions for the last few years, with very limited actual number of cases to show for it, but they seem to be on that path. So I don't know if you want to contradict me on this.
I was looking at mainly from a German perspective, to be honest. I'm aware of the Netherlands, but they tried a few of those bigger cases like elevator, cement, beer cases and stuff like that. In Germany, it doesn't really work well.
But that's why in the US, antitrust is a preemption of federal courts. It's also just to have one federal court and procedurally under federal law. So that comes back to one of the points made this morning about having European courts in all member states being closer, because the fact that if you want to do some antitrust actions, it will be national rules, and then you have these regulatory barriers across border. So we need European courts, district courts all over Europe, rather than just one single court in Luxembourg, which is so far away when you're in Finland, Portugal, Greece, or Ireland, just geographically, but also institutionally, there's some barriers. So in order to avoid that, there shouldn't be class actions or private enforcement in national court because of the national procedural boundaries.
Meanwhile, the U.S. is fragmenting in that respect.
Yeah.
I mean, we've always had the Cartwright Act in California, which is more prescriptive, and now it hasn't happened yet, but New York's Assembly, the last previous session, seriously considered introducing abuse of dominance as a violation of the Connolly Act. I mean, I think it would be a disaster for the states that do that and for the country as a whole, especially those big populous states. But it's right there around the corner. And of course, we've had a majority of the states have rejected our Supreme Court's decisions with respect to direct purchasers and allow recovery by indirect purchasers. Some other variations like that. So it's not as if the U.S. has a uniform scheme. It's that much more than Europe. Sir.
Derenberg from University of Oregon. Thank you for the panel. I appreciate it a lot. I want to start out with just one brief note and then ask a larger question. And the brief note is in an interview with a private antitrust lawyer named Gary Rebeck, who really was, from the outside, was the architect of the Microsoft case. Rebeck told us that he will often include these days in private antitrust suits aspects of the suit that he knows will fail in order to signal EU regulators about the possibilities of introducing new aspects of regulation. So there is a kind of subterranean, cross-border work that's going on. But I wanted to ask about something else, which is, I myself did some research recently with Annalise Saxenian from Berkeley we were looking at an antitrust debate that's brewing in cloud computing. Because in cloud computing, there's this enormous layer now of emerging of middle-level layer of database companies, very independent entrepreneurial database companies. And famously, what's happened is Amazon, they place their stuff on Amazon Web Service, cloud services, Amazon Web. All of this stuff is open source, and Amazon says, "Oh, we have open source databases. We'll appropriate their code, bring it inside of our suite of services." And so those folks are beginning to try to think through whether there's an antitrust strategy there. So we went to do research on that. The thing that surprised us most was how critical in this, so much stuff is moving towards software as a service and into the cloud. And the thing that surprised us the most was how much innovation at this point is dependent upon the nonprofit sector. Critical innovation at this point. Some people now say, a woman named Sarah Novotny, who was head of open source at Microsoft, says now that 94%, I don't know how she calculates this, but she says 94% of software in the world is now built on top of open source. So when we got into it, we could see that Amazon is a very central, so this is partially an observation for Abraham Newman. Amazon is very much what you described, deeply centralized. But in order to compete with Amazon as a latecomer, Google, in fact, has pursued exactly the opposite strategy. Google created an interoperability innovation called Kubernetes, which allows movement across platforms in a very kind of complicated way, and it ceded it to a subsidiary of the Linux Foundation to run it. And now Google, in fact, is using that as an edge to build partnerships with database companies instead of dominating them. So, so I guess part of that calls into question this idea that for me, this is all a question of the nature of how property rights is going to work, And so I don't think that there's any inevitability in the structure of the industry. I think it's going to be a battle both over property rights and over competition policy.
We have 1 minute. Abe, do you want to say something?
Well, I would just say that, so in our book, we have a section that's about crypto, and I think that what you see is that there's always efforts in industry to decentralize systems because they're trying to overturn incumbent advantage. And so they do that. But then they realize that they can't make any money off of decentralized systems. And so then they layer a central marketplace infrastructure on top of that to extract the funds. And that's when then the government has a way to retap into the control function. And so I would just give you the example is Binance. Binance was a centralized marketplace that was layered over a decentralized technology. It was, everybody thought they were still using some decentralized system, but it's a company that's taking all the money. And the US government then could, everybody was like, well, crypto is beyond regulation. Well, as soon as you have that layer of centralization, then the government taps into that. They find them that they've been doing fraud. They get a deferred prosecution agreement. And all of a sudden, Binance is layering information up to the Justice Department as like a wiretap on the crypto industry. So I'm more skeptical of that we can decentralize, because firms ultimately, they want the rents, and it's hard to have rents when you really decentralize.
Well, it's been a great discussion. Thank you all. Please join me in thanking the panel and our entrepreneurs who programmed this.